Sure. So there are a ton of misconceptions about what HIPAA law covers. HIPAA is a federal statute, and it was put into place to govern three particular entities. These are called covered entities. The first one is insurance companies. So that runs the gamut of all health insurance companies. But believe it or not, it doesn't apply to certain situations like life insurance. So even then, it's limited. The second category is healthcare providers. So doctors' offices, physical therapists, the whole gamut there. And then the third is clearinghouses that process medical information or help do insurance billing. That's it. And those three entities, if they have subcontractors, so in other words, if they hire a lawyer or if they have an IT person that needs to come fix the computer and they see health information that's confidential, then that would also be covered by HIPAA. But outside of those entities, nothing else is covered. So that means that state administrative agencies, so the New York State Department of Health necessarily might not even be covered by HIPAA under the letter of the law. Additionally, police officers, police enforcement, things like that, HIPAA doesn't cover that. So in the US, I can't really speak to every state, but speaking more specifically to New York and to an extent Pennsylvania, the public health law in New York is what covers these types of discussions and situations. And there are no privacy portions or subsections of that law that would give individual protection to knowing somebody's status as to whether or not they've had a vaccine. So in other words, I think that when people are worried about proving whether they have a vaccine and the privacy concerns associated with that, that is actually a lesser concern to the exercise of state power than actually making somebody get a vaccine. So the law has held, and this has been the law since smallpox. The Supreme Court has stated that states, individual states, so New York, Pennsylvania, et cetera, they have the power to put into a place a law that says everyone has to get vaccinated. Vaccinations are mandatory. Now they would have to make health exceptions for that and possibly some other exceptions, but the state, no question, has a power if they wanted to make vaccination mandatory. And they have exercised that with regard to students, kids under the age of 18 using public services like schools, things of that nature. Now, it's very strange to me that in social media and in other places, there has become almost this obsession with privacy and like knowing whether or not somebody has the status of a vaccine. That's not covered, really, it's not contemplated by any law. The only people who would have to keep your vaccine status confidential would basically be the person who administered the vaccine to you. So whether that was a pharmacy or a state site or your doctor, they're covered by HIPAA, but everybody else, if your employer wants to know whether you had a vaccine, you have to tell them. If the sports venue decides we're only going to let in vaccinated people, then your choice is tell them or don't go. Again, this kind of falls a little bit outside of the legal ambit, but if I had to speculate as to why this has changed and we haven't had a similar concern with prior vaccines, I would say that there's a lot of new technology out there. The Excelsior Pass, for example, is based on blockchain technology. A lot of people just use blockchain as a buzzword. They don't really understand what it even means. So I think that there's a lot of things out there that are scary to people. But basically, when you give your information to the Excelsior Pass, you're giving it to two places. You're giving it to IBM, who runs the Excelsior Pass and came up with the blockchain technology that is allegedly supposed to protect your information, and you're giving it to New York State. And then after that, if you want to go to a particular venue, they're not really getting a lot of information. They just know that this particular person has been vaccinated, but it's not necessarily going to be linked to like Anna Zarpels has been vaccinated. Here's all her personal information. There's no additional way that at least we know of so far to get more information than what is given by the pass. But again, these are all untested things. And I think that untested technologies, and the first time we're using blockchain technology and an app to store, even minimal medical information about a vaccine, people have concerns about their privacy, and those are valid concerns, which I understand. But from a legal perspective, there's no violation of the law in these technologies, at least to date. Now, if they lie to us and we figure out, a year from now, it was different than what they told us, then it might be a different situation. But as of right now, everything seems to be legally acceptable. And it's just scary for people. That's why we're having these issues. in the private versus public realm, for public institutions, so if there was some type of event that the state was running, so for example, the New York State Fair or perhaps county fairs, and they made a decision that, this is hypothetical, obviously, but if they made a decision that they only want vaccinated people to attend those events, they could pass a law or regulation requiring that, and then you could decide, either you're going to get vaccinated, tell them about it and go, or not. They have that power. It's well settled under the current state of the law. They, again, have to provide for particular exceptions, like health exceptions, but they have the power to do that. Now, taking somebody else, like a sporting event, the Enforcers, the Bills, the Sabres, the Orange, etc., they kind of have two obligations. Number one is, as a private entity, they can kind of decide, what they want to do. So, for example, going to, a Sabres game, they get to put the rules in place, but they also have to follow New York State regulations. So if the state says you cannot be open unless A, B, C, and these have been tested in court, a lot of these restrictions. So as long as those restrictions are reasonable, as long as they're being enforced uniformly, then the private entities have to follow them. Now, let's say that hypothetically, it's a year from now, and New York State has said there are no more regulations on sporting events. Then a private entity could decide for itself to say, we want you to have the COVID vaccine, otherwise you can't come in. Again, you have to have some minimal exceptions to comply with the ADA. But other than that, they can make their own rules about who they want to attend. Private corporations can make any rules that they want as long as those rules aren't discriminatory. So, for example, if a sporting venue said, we don't want people of this race coming to our sporting venue, that's obviously legally unacceptable, and they're not allowed to do that. But as long as they're making a neutral rule, so we don't want you to wear blue hats at our games, they're allowed to do that. And they're also allowed to say, we're not going to admit you unless you have the COVID vaccine. As long as they have a health exception, that's perfectly acceptable. There's no discrimination based on people who do not want to get vaccinated or do not want to get a COVID test are not a protected category like race or sex or religion. That doesn't have anything to do with it. If they're saying they have a religious objection to the vaccine, then that could be a little bit different. There's probably going to be some litigation involved there. But if the venues make a reasonable accommodation for religions, then it's going to be very difficult to fight those rules. The answer is that we don't know yet. I'm sure that there will be challenges based on the fact that it is an emergency use vaccine. However, under past examples of the emergency use doctrine, it has held up pretty well that an emergency use of a drug, or believe this is the first time we've had a vaccine under emergency use in a long time, but it has happened for medications. And in past cases, the emergency use has protected the manufacturers from being liable for various events. So in our federalist system, when you enter a state, you are under the rules of that state. New York doesn't care about what Florida's law is and vice versa. They all have their own laws. And if New York puts into place that you need Excelsior Pass and you're a resident of another state and you want to attend a New York event, then you have to comply with New York law. So that's just the way it is. So that wouldn't be a concern from New York's perspective. So again, I think that the fears about apps are a little bit overblown. Obviously, I do have some concerns about blockchain technology, and that blockchain technology is really legally untested. We don't know if it's going to be a secure network and that type of thing. But if you put those security concerns aside for a moment, using an app to demonstrate that you have been vaccinated is exactly equivalent to providing a vaccine card. There's no difference except that one is digital and one is a hard copy. So from a legal perspective, those two things have exactly the same value, and there's no constitutional or other concerns with forcing people to download an app. I will say that the concern would not be necessarily from a legal perspective, but possibly from a socioeconomic equality standpoint. There are certain people who would like to attend events, some elderly people that don't have smartphones, some other people just don't like smartphones, some people cannot afford to have smartphones. So it would make sense, although it would not be legally required of people to have some other alternative, like possibly showing the vaccine card in order to establish that you've been vaccinated in order to attend an event. I don't think so. Like, just as I said in the beginning, the HIPAA law is one of the most misunderstood federal laws. I think that a lot of people think that if they tell somebody their medical information, that somehow that's a private and secret transaction, especially with employers. But 9 times out of 10, even with employers, that is not protected information. So it really only protects a very small percentage of medical information. It does protect you with your medical providers and insurance companies, but beyond that, you're really stretching it to think that HIPAA is going to protect you.